Hey, good afternoon, everybody. This is Brittany with the Seniors Blue Book, and today I am joined by Ira Wiesner and Daniel Smith of Advocates in Aging. Good afternoon, gentlemen.
Hello, good afternoon to you.
I'm great. I'm having a wonderful Wednesday. And how about you guys?
Happy Earth Day to everyone, too, by the way.
Yes.
Ah, yes, I should have had a big Earth globe behind me or
That's
something
right.
like that.
No, but you have nice nature behind you.
You
That's
did.
right. That's right. And I'm still wearing my sunscreen. It's a
Okay.
So I want to introduce, of course, each of you real quick, and if you want to give a little bit of a background on Advocates in Aging. And today I'm excited, and I really appreciate the time you're taking with Seniors Blue Book today to go live and talk about the documents that you need during this time, as well as advocating for your loved one during the challenging time. So thanks for spending some time with us. I know you're super busy. But let's start with Daniel. Let's start with Daniel and kind of his path into Advocates in Aging.
Sure, yes, I joined IRA in November of 2017. Before that, I worked at about a 15 attorney firm in Virginia practicing civil litigation and did a federal clerkship before that, but focused mostly on elder law and estate planning. So what's important about that today are a lot of the important estate planning documents that you need in place, and Ira's going to introduce those in a minute. But those we're seeing an influx of calls now of kind of different issues involving COVID-19. And so we want to address some of the issues and the practicalities now that we're under a stay-at-home order, and meeting with our clients has become more of a burden.
Absolutely. All right, let's jump over to Ira.
Well, we've been doing this for a very long time. I came into the practice of law as a tax lawyer, and in the early '80s, it became very clear that the legal needs of elderly clients and their families became more predominant. And so we've been across the board as far as advocating, both in terms of the legal work we're doing, but also in protection of elders from exploitation, incapacity. Reverse mortgage issues are becoming a really big issue right now, and protection from fraud, abuse, financial exploitation, that kind of thing has just become rampant. And so Advocates in Aging has become multidimensional. And we're very happy being able to do what we can do. And education. Education is really the most important thing. It's not what you know. It's not what you don't know. It's what you think you know that ain't necessarily so. And so that's what we want to be able to present to you, to give you some guidance and some things to think about.
Thank you so much. These two topics that we're talking about and them tying in together is so important. Like you mentioned, right now during this specific time, people really do need a resource such as Advocates in Aging to reach out to and to have this information. So I'll be happy to hand it over to you two, and we'll go from there.
All right. There was a great article the other day, and maybe Daniel will remember the source of it, but it had to do with a healthcare provider who started to think about what's going to happen if she gets sick, and who's going to take care of her kids, who's going to know what to do, what's going to happen, who's going to pay her bills. And it got us thinking that really we should be clear as to what people need in place. And Daniel and I were discussing it this morning. And here's the sad thing, and everything has changed as a consequence of the coronavirus and the COVID illness. And it happens very fast. And I think this is the most important thing people have to keep in mind. We're all procrastinators. None of us get to do the things we need to do way in advance of when we need to do it. That's just part of human nature. However, in this particular situation, I think what I've seen from the medical reports has been that if you come down with this virus and you start showing symptoms, it's very likely, if it's going to be a bad case, you're going to be pretty much out of it right from the get-go. You're going to have headaches. You're going to have body aches. You're going to be running a fever. You're not going to be clear thinking. You're not going to be able to say, oh my gosh, I think I have COVID-19. I think I'm going to get my affairs in order, because The hard cases are getting to the hospital within 2 days. You can't even operate like that. And so you have to put these things in place before a crisis occurred. And so we're going to talk to you about 7 legal documents that you may or may not need. Some of them you absolutely have to have. But some of them, they may not apply to you. But if you have a picture of what you can put into place, you can always change these documents later. But it's important to have them in place. The problem we're having today is that getting the documents executed has become a real challenge. And Daniel is going to tell you about that as we get done telling you about the documents themselves. We have ways of getting them executed. Lawyers have figured out some ways of doing this. They're not perfect. They're not without some risks to somebody's health, but we're getting things done. We have to get things done. And so let me give you a breakdown of what we think the important documents are. The first document, and Daniel's going to talk about it the most, is the durable power of attorney. And the need for having someone put in place to be able to take care of your business if you become ill and can't take care of it. Issues like your mortgage payment, contacting your insurance company and getting the information that's needed, doing your banking. All these kinds of things require someone to be able to do it if you're locked in a hospital room or in a skilled nursing facility or assisted living facility that is on lockdown. The second, and I think for me the most important documents, are the Advanced Healthcare Directive and the Living Will. And the Advanced Healthcare Directive says, this is the person who can make medical decisions for me if I'm unable to. And the Living Will says, if I get to the end and I'm just not going to make it, don't keep me on the machines. And we'll talk about that more when we get to that. Then there are guardianship issues. Not putting someone in a guardianship, but actually making sure that if something happens to someone, they've designated who they want. You don't want to have a court fight over people saying, well, I'm in charge or I'm in charge. There are 3 kinds of documents involved. They're called pre-need guardians and standby guardians, and Daniel will explain those. And then finally, we're going to get to who's going to get the stuff, the will and the trust. In the hierarchy, we put that down at 7 because there are options that would come into play if you haven't done this. But they're not the urgent things. They're not the things that have to be taken care of immediately if something has happened to you. And so I'm going to turn this over now to Daniel, who's going to talk to you about the durable power of attorney.
All right, thank you, Ira. I think the important thing first is to distinguish what a power of attorney is. I've read stories before where there was an individual who was designated as a power of attorney and tried to advocate before a judge in court. If somebody names you as their power of attorney, that does not then deem you an attorney to practice law, right? A power of attorney in the Florida statutes means a writing that grants authority to an agent to act in place of the principal. So really, it's a writing, an instrument, and you're designating somebody to act on your behalf. The durable part means it's not terminated by the principal's incapacity. So like Iris said, if the person who's making out the document later becomes sick or even worse with COVID-19, right, the document will still survive and the person that you list as agent under that document can still act on your behalf. So really think of it as the agent is stepping in, making the decisions that you would if you had that capability. It's important now, as Ira mentioned, to have this in place because if for some reason you contracted COVID-19 and got sick, you need somebody to pay your bills, right? Especially medical bills and keeping all your other bills on track if you need to go into a medical facility. Sign contracts. When you're admitted, you're gonna need somebody to sign these sign agreements with the facilities, the medical providers, and you may not be able to do that. There may be no time by the time you get sick and enter the hospital to be able to sign these documents. Third, you want to make sure your home doesn't go into foreclosure. Have somebody making sure to communicate with the mortgagor to make sure that your bills are being paid and anything, or you can get some kind of delay on making your mortgage payments if needed. And finally, of course, you need somebody to get access to your health insurance documents, and that agent will have authority in there. All right. So the important thing is, what do you need to put in that document? There is language under the Florida statutes that you need to put in, which will be recognized. As long as it contains something similar to, this durable power of attorney is not terminated by the subsequent incapacity of the principal, then that's going to be acknowledged in the state of Florida. Now, you can't just say, well, my agent has authority to do all the acts that my principal can do. No, that's not going to stand. You need to specifically enumerate what powers that you want to give your agent, right? If you want them to have the power to access your financial accounts, you need to say it. If you want them to be able to have control of your digital assets, right? You know, any of your emails, you need to state that. Your online banking, that needs to be in a document. You can't just say, my agent has authority to do everything I can do. That's not going to work. So that's a really important thing to consider. And we'll go over how to get the document executed later. But I want to lead into Ira, who's going to talk about advanced directives for healthcare and living wills.
Okay, thank you, Daniel. Now we get to the issue that for me is the most important, and that are the healthcare decisions and the decisions you make under these kinds of circumstances. And there are two legal documents involved. One of them is referred to as an advanced healthcare directive, or the appointment of a surrogate. This works just like the power of attorney, but not for financial issues, for healthcare decision making. It involves, number one, you appoint someone to act for you. In this area of the law, they call it a surrogate. They don't call it an agent. It's the same thing. You don't worry about that. So you appoint someone to act for you. You give them the authorities to make certain decisions on your behalf, to sign you into, to get you into the facility or the hospital, to sign the releases. If you've ever been in a hospital, admitted, you know that you're going to get a pile of paperwork like this. If you're ill, you're not going to be reading this, and you're not certainly going to sign it. So they have to be able to go through this, go through the documents, sign in, give the releases so that you can be treated. How that surrogate document is done is very important, because I wouldn't want to be called from the hospital and be told, Joe Smith has named me as his surrogate. And we've never talked about his wishes. We've never discussed what he wants done. He never even told me. Now, this is just an example. But the point is, when you make someone your surrogate, it's important you at least have a conversation with them so they know what it is that you would want done under the circumstances. So you can have just a designation of a surrogate, or you can have a designation with all kinds of things with it. Important, absolutely essential, is a HIPAA waiver, a HIPAA disclosure. HIPAA is the Health Insurance Access Portability Act, blah, 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 from 1980, I think. In any case, nobody can get medical information about you, about your condition, about what's going on, get a second opinion without that information saying they have HIPAA authority. That's why when you go into the Walgreens or the CVS these days, there's little lines. And it happened before COVID. And that was because you didn't want to be standing at the pharmacy talking about your personal prescriptions, and the person is right over there looking over your shoulder. Now they have to be 6 feet away at least. But in any case, you want to have the HIPAA authority in there. The other document is a living will. Now, the living will is a document that says, if I am in a condition, we'll call it a terminal condition, we'll call it an end-stage condition. This is when your opportunity for recovery is really limited, if not non-existent. And it says what you would want done. Do you want to be kept alive on ventilators? Do you want to keep alive if you have to have a peg tube put in? What limitations do you want to have before these devices, intrusions, interventions are withheld or withdrawn? Interestingly, when this first became part of the law, the norm was everybody thought you didn't want these things, and it became common, I would just say, procedure to assume that everybody wants things pulled. It turns out that a lot of people don't. And if your position is that you really want to keep being treated, as long as there's a chance for recovery, you have to almost say that specifically, because there's an assumption there that you want to have the plug pulled. So this brings up a really fascinating issue. It's great for lawyers to talk about, but I'm going to bring it up for you to think about. And that is, with the COVID situation, the question becomes how long someone wants to be on a ventilator. In our documents, we've always focused on the difference between the coma being an accidental coma, an injury coma, an illness coma, or a medically induced coma, meaning the doctors put you into a coma. Very, very often when you have a head injury, a trauma, a car accident, you hit the windshield, the brain has been damaged and harmed. And what the doctors will often do is induce a coma to give the brain an opportunity to heal. Now we're in a totally different environment. Now, with the COVID-19 problem, we've all heard about the ventilators, the people going on the ventilators, and now we're hearing about how maybe 2 out of 8 will come off the ventilators. And even the 2 that come off are not going to have the greatest health coming off. There's going to be residual issues here. So the question is, if you have a document like that, take a look at it. What does it say? Is it going to be used to say, this person doesn't want to be ventilated, period, even under these circumstances, even if they can't breathe? Because if it's just to say, I don't want to have ventilator, I don't want to have any artificial breathing, you're done. That they could take that as your declaration that you're going to let someone else have that ventilator. There's going to be a lot of questions about this. There are no clear answers, but it's something that you really need to think about. We're going to be, in our documents, adding a separate COVID provision that deals with this. It's going to be based on the medical data that we're being provided as to how long that time frame of being on a ventilator with COVID is a probable possible recovery or an improbable recovery. But you want to have that declared so someone knows what your treatment choices would be. The final thing I'm going to bring out about this, and it kind of goes with who you name and telling them what you want. Sometimes we don't think about these questions. We put them into broad statements, very simplistic. The worst one is, I wouldn't want to live like that. And if you read all of the cases in this area, someone always gets on the stand and says, they were watching TV with me and we saw this horrible thing on TV, and the person turned to me and said, I don't want to live like that. What does that mean? Who's going to understand that? Now I'm going to try to do a share screen. Could I try to do a share screen there, Brittany? Mm-hmm. Can you do that for me?
Absolutely. Okay. You can do it right from your taskbar at the bottom. Just hit share screen.
I'm trying to. It just says host disabled, participant screen sharing.
Oh, let me see. Let me try something real quick. I'm going to change the host over to you and see if it'll let you do it that way.
Perfect. Here we go. So what I'm showing you here, thanks, Brittany. What I'm showing you here is a toolkit. We call it our toolkit. And the toolkit starts out with, I couldn't live like that. And it goes into an entire story of this, and then it goes into a series of questions, and they're set up as scenarios. If you were in this situation and these were was your data, what would you want to be done? And it gives you choices. It also lets you know what things are important and what things aren't important. And what it does is two things. One is it gives the person that you're designating a sense of what it is that you're directing them to do. Remember, when you have a power of attorney or an advanced healthcare directive, what they're supposed to do is what you would do, not what they would do. So it's very clear so they understand your wishes. Secondarily, it resolves a lot of guilt after the fact. If you've ever been in a situation where you have been that healthcare provider, you would find that it's the biggest decision you ever made in your life. And you really don't want to have the residual guilt. What you want to do is be acting as if this person told me they want me to do this for them. I'm going to do this for them. And I'm not going to say that's my decision. They've told me. So those are the three things there. We are going to, if you would like this toolkit to work through your medical healthcare decision making as a tool, if you contact us, and our number is 365-9900, or if you email us advocates@wiesnerlaw.com, we will provide you this toolkit at no charge.
Wow.
It is, for my purposes, it's been one of the best things we've been able to introduce. And we give it out freely because it makes a significant difference if it's ever needed to be implemented. And so with that, I'm going to turn this over now to Daniel, who's going to give us an insight into the legal documents that might be important for someone with the words guardian. Daniel?
All right, Brittany, I know the viewers are going to have trouble believing this, but not everyone's family members get along, especially those with blended families. So we often run into the case where maybe a senior or an elder has already executed a power of attorney, an advance directive for health care, and they're living well and their HIPAA documents. But maybe there's another family member who doesn't think that that person should be in control, and maybe files a guardianship action to seek to be appointed as that person's legal guardian, right? Of course, the court's going to look at any lesser restrictive alternatives, but there might be a case where they argue that the person listed, he's the no good family member and we don't want him to serve. In that case, how do we state if that, how do we provide for if that were to happen and the case were to go before a judge? How do we tell the judge who we would want to be appointed as guardian? Well, that's what's called a declaration of pre-need guardian. And what that is, a pre-need guardian means a person named in a written declaration to serve as guardian in the event of your incapacity. So when I say a written declaration, you're saying under penalties of perjury. And Florida requires at least 2 attesting witnesses be present at the time you execute it. So of course now we're in COVID-19 and we're trying to keep social distancing. So we're having to work around both the COVID-19 restrictions and the legal requirements of executing these documents. But essentially, once you designate somebody as your pre-need guardian and get that witness, you can file that with the court, and so the clerk will have it on file should anyone ever file a petition to determine incapacity for you. And what it does is it creates a rebuttable presumption, right? It's not set in stone, but it's going to be really hard to overcome if the person making that declaration is saying, this is who I want to be my guardian, and you're trying to advocate against that for some reason, right? And you want to do it as soon as possible too, because the judge is going to question if you assign this right away, and then a petition determining incapacity is filed like the next day. So it's going to, the judge is always going to take these factors into account. The sooner you get this filed, the better. You don't have to file it with the court right away. If you prefer your attorney to hang on to it in case something happens, that's fine too. Another important guardian document in the times of COVID-19, particularly with our healthcare workers, are a pre-need guardian for a minor. who's going to take care of my kids if something happens to me, right? And so it's a really important document. It's a written declaration that names a guardian to serve if the minor's last surviving parent becomes incapacitated or dies. So that's important to have because you don't know what's going to happen, especially if you're in the healthcare industry. And, with the spread of this disease, it's unfortunately easy to see the case where one parent gets infected, transmits it to the other parent, and then we're left to decide who's going to take care of the kids in the meantime. Again, this document needs to be signed in the presence of 2 attesting witnesses present at the same time. So we need to work around our social distancing to get these documents executed. But it also creates a rebuttable presumption for the court should somebody file notice of death or notice of incapacity of the parents, right? A third one, another thing to think about, what if the person that I designate as my guardian, they die, right? So now you're in the case of, oh my gosh, well now who's the court going to appoint? You can actually designate what's called a standby guardian, right? That way, if something happens to your guardian, you already have it on notice who you would want to serve as that backup guardian. Now, this has to be served on, you have to set this for hearing unless a waiver is required. But again, that will be done at the time it's needed. But it's important to have a backup standby guardian appointed just in case something happens with the health of the guardian, which does happen. And we see that. Okay, so now I'm going to send it to Ira to talk about the documents that were kind of towards the end. What happens to my stuff when I pass away?
Thank you, Daniel. So everybody knows about wills. Everybody knows that there's also living trusts, and they can be different documents for different purposes. And the major issue we're dealing with is what's going to happen to my stuff if I die, and who's going to manage it. Those are the 2 important things. I'm not going to focus a lot of time on this because these are documents that everybody knows they should have in place. So many people don't. Over the course of my career, and Daniel, I'm sure, has been experiencing this as well, clients will come into the office and they will begin the conversation. This is what I would like to have happen if I die. Well, in the environment we have today, if is not as big an issue as when. And so you have to take these considerations, and in your planning, everything is done in advance so that there's no questions of who gets what, who's in charge, how you want things to operate. If you don't do it, if you don't have a will and you don't have a trust, the law will step in. But the way we consider it is, if you don't do it for yourself, the law will do it to you. So it's taking it into your own hands that becomes very important. So those are the 7 legal documents that we feel should be in someone's portfolio. And they're not complicated documents, and you don't have to have a complicated life to have them, but they're going to make the most important if something, God forbid, should happen to you, particularly with this crisis that we're into now. Now, in terms of how would one do that? Well, how would one get something prepared for them? They could go to an attorney to prepare this. They could certainly probably go on LegalZoom and do it. How you get it prepared is not today as difficult a question as how do you get it signed? And if you were paying attention to some of the examples Daniel gave, you would have heard that he said, well, you have to have 2 witnesses present. Here's the bottom line. In every one of the documents we've talked about, in every statute about it, they always say the exact same thing. They must have 2 witnesses who are present with you when you sign. And that is the big problem with the COVID situation, is getting 2 people to be with you when you sign. The creativity in trying to overcome this dilemma has come up with some funny results. in our practice, we have basically decided that if we have our masks, and you see Daniel's is in the background and mine's right here, and we have little gloves, they're not latex, and if a client needs documents, yes, we all have, Brittany's are the best. Brittany's is the best because
it's got unicorns.
It's got unicorns on it. And so, I'm going back to, so how do we get two people present? We took the position that if you're on a Zoom like this and we see you, we're virtually present. Unfortunately, having done the legal research, there is nothing in the law or any case that has dealt with it that doesn't focus on presence being place. And so how do you do that? Well, what we've done is we have a procedure, a protocol, where clients can come to the office, they sit out in the parking lot, they call us, we come out with their documents, we're all geared up, we can hand them to them through the window, we can watch them sign, we take the documents back, we put them in a closed conference room, we spray the Lysol up there, we leave them for 72 hours. We think they're okay now to process. So that way, you don't have to redo them later. We've talked to some lawyers who have tables set up in front of their front window where they let the clients walk up and sign, or they have some way inside their office to block people and keep them separated. The best we heard today was, and this gets to the whole situation of family members in skilled nursing or assisted living where you can't even get in to be with the client. What one firm did is they took very large ladders, they put them up against the side of the building, climbed up to the second floor, and watched the resident sign the documents through the window. We thought that was very creative, but I'm going to have to say that we won't do that. I'm sorry. Ladders and Ira don't go well together. No, we won't do that, but getting the witnesses is really the hardest part of going forward with this. And unlike other states like New York and like Florida just has not addressed this in a reasonable fashion. What they have addressed is notarizations, and I'm going to let Daniel handle that part. Daniel?
Yes, thanks, Ira. There was a very important order that was issued by the Florida Supreme Court on March 18, and it was called for remote notarization authorization. So basically, it stated that notaries may swear a witness remotely by audio-video communication technology, such as Zoom, right, from a location within the state of Florida, provided they can positively identify the witness, and if the witness is not in Florida, the witness can consent to being put on oath by the audio-video communication technology, by that notary. So we've had the case where we've needed certain oaths signed, and we can't physically be together, but we're able to actually notarize these documents via Zoom. So that's been really helpful as far as that's concerned, the notary, right? And part of that order, it stated that all rules of procedure, court orders, and opinions applicable to remote testimony, depositions, and other legal testimony which either limit or prohibit the use of these audio-video technologies, those are now suspended until further order. Right now, it's extended through the end of May, through May 29th, which is the last Friday in May. I'm predicting now that it'll likely be extended further as the courts are now adjusting to Zoom video conferences for their hearings. It's good in the sense that the courts are adapting. We're getting new orders from the courts. It seems like almost on a daily or definitely a weekly basis, as to more judges that are allowing for Zoom technology and kind of adapting to the current circumstances we're in. So it is new for them too. It's new for everyone. We're just trying to adapt and go forward. And, we understand the severity of this disease, that it's a virus. It doesn't, play sides. And we really need to take it seriously, but also understand that there are important legal documents that we need to get executed too. And so we need to adapt to that to make sure that we're just not stopping everything, but also doing the best we can in light of COVID-19. All right, Ira, closing remarks?
Sure. First of all, I want to thank SBB for hosting these information opportunities. Putting information out there gives people power, and power gives them the ability to protect themselves and the ones they love. And so I want to thank you, Brittany, for your efforts, which this is only one little bit of it. The other thing I want to just, because I gave our address and email real quickly, we are in the Senior Blue book. And so if you need that information, we're readily available there, or I'm sure you could either call us or Brittany to get that information. But thank you very much. If we can say anything of consequence here, it's please be careful and please be safe. Too many of us have had someone that we know or someone that we love become a victim to this situation. And even if they recover, we know they still have problems. It's not a light switch that says, I'm good today, I'm bad tomorrow, I'm good again. So be careful and be safe, be wise. Thank you.
Thank you so much. I appreciate, again, you and Daniel spending all this time with us this afternoon and educating and truly focus on the importance right now of these documents. If somebody is able to reach out to Advocates in Aging just to get information, just to start, just make the first phone call to get that process going. And I want to say that please don't get on a ladder. I had a visual, but if you do, maybe Daniel, just tell me and I'll come out and I'll film it from like 6 feet away.
Definitely film. Oh, yeah, we're gonna film it.
We'll get it like as a news story, you know, with Daniel up there, but no. So I'll make sure to add your information as well to the post so people can reach out to you. And again, thank you so very much for being partners with us and for giving all this very useful information today.
Great, thank you. Bye-bye.
Thank you very much, Brittany.
Bye, have a great day.
Bye-bye.